Ready? Start. The learned counsel for the respondents also argued that the appeal was not maintainable in view of the fact that the order under appeal does not affect the rights of the parties and such was not appealable. We have considered the rival contentions of the learned counsel for the parties. In our view, the first and foremost question for consideration is the power of the court to grant exemption from payment of the prescribed court fee. In this connection, for the relevant provisions of law are Section 4 of the Court Fees Act and Order 7th Rule 11C CPC. Section 4 of the Court Fees Act is couched in a language which shows that payment of court fee prescribed in the first or second schedule to the Act is mandatory before a plaint or other documents or instrument referred to in the section can be proceeded with. Section 4 as applied to State of Delhi covers the ordinary as well as extraordinary original jurisdiction of the Delhi High Court. Further, as applicable to Delhi, Section 4 of the Court Fees Act reads, no document of any of the kinds specified in the first or second schedule to this act annexed as chargeable with fees shall be filed, exhibited or recorded in or shall be received or furnished by the High Court of Delhi in any case coming before that court in exercise of its ordinary or extraordinary original civil jurisdiction. It is not in dispute that ad valorem court fee is payable on the plaint as in the present case, and in fact the plaintiffs have stated in the plaint itself the amount of prescribed court fee in this behalf. The language of Section 4 puts a complete embargo on the power of the court to proceed with or act upon a document of any kind, including a plaint in the suit, unless it bears the prescribed court fee. This brings us to the Code of Civil Procedure, which governs the procedure for trial of the suits of civil nature. According to subclause C of Order 7, Rule 11 of the Code, where the relief claimed is properly valued but the plaint is written upon paper insufficiently stamped, and the plaintiff, on being required by the court to supply the requisite stamp paper within a time to be fixed by the court, fails to do so, the plaint shall be rejected by the court. There is a proviso according to which the time fixed by the court for the correction of the valuation or supplying of the requisite stamp paper shall not be extended unless the court, for reasons to be recorded, is satisfied that the plaintiff was prevented by any cause of an exceptional nature from correcting the valuation, supplying the requisite stamp papers as the case may be within the time fixed by the court, and that refusal to extend such time would cause grave injustice to the plaintiff. Thus, under Order 7, Rule 11, if the court is satisfied and after recording reasons for doing so, the court may, in cases of exceptional nature, extend time when it feels that refusal to extend time would cause grave injustice to the plaintiff. This power is to be exercised in cases of exceptional nature and not in routine. The power is confined to extend time for making up deficiency in court fee and nothing more. These provisions of the Court Fees Act and the Code of Civil Procedure, in our view, do not leave any power with the court to grant exemption from payment of prescribed court fees. The only power which can be exercised in cases of grave injustice or hardship is to extend time for payment of court fee, and if the plaintiff fails to do the needful even within the extended time, the plaint is liable to be rejected. Stop.